First of all, let me just say that compliance. It could never be stressed enough how important it is to ensure your compliance with U.S. immigration laws. That includes, for purposes of your student status, making sure that you are in close contact with Mary Beth and her office to make sure that everything is in order in terms of your classes, in terms of your status, in terms of your record with SEVIS, the Student Exchange Visitor Information System, which Mary Beth monitors on your behalf and on behalf of Duquesne. So please stay close with her office. Make sure you are remaining compliant. There have been many changes to immigration law over the past 10 or so years. But one thing that has not changed is the need, in particular, for students to maintain their status to make sure that they are legally in the country. Number two is the issue of communicating with your employer. Yesterday, I'm sure you heard about filing deadlines for OPT, potential STEM extension filing deadlines. It's really important, everybody, that you make sure that your employer is aware of all these things and that you, to the extent necessary, communicate with your employer about your immigration status and, if applicable, what the employer has to do. For example, if you're going to be qualifying for a STEM OPT extension, again, I'm sure you discussed that yesterday, the employer needs to participate because the employer needs to complete a form that is included with your application. So communication with the employer is really important, and communication with the employer after you are working there and you are considering other options that we will discuss today is equally important. You need to understand where your employer stands with respect to immigration, because guys, if we end up talking today about H-1B visas and green cards that are based on employment, and you have an employer that is not going to be willing to, quote, sponsor you, then I think that really makes you think about, is this the right employer for me? Okay, that's an important discussion to have. Of course, I realize that you got to get a job first, and then you have discussions like that with employers, but it's really important to be mindful of some timing concerns and make sure that you have that communication, those conversations nice and early. Okay, so dovetailing from yesterday, we left off, I'm sure, with Mary Beth and Aaron with discussion of you are working at an employer, you've graduated from Duquesne at the end of a 4-year or a master's degree or maybe a PhD program. You are eligible for 1 year of post-completion of studies, practical training, and in some cases, you're eligible for an additional 2 years of STEM, science, technology, education, math discipline, optional practical training. Remember, by the way, that that STEM extension is only available if you are joining an employer that is an E-Verify employer, E-Verify. And again, maybe this was mentioned yesterday, but it's important. Don't assume that that employer will qualify for a STEM extension for you. Just because you have a degree in one of those fields doesn't automatically mean you'll qualify. You got to make sure that your employer is an E-Verify employer, which basically means that they verify employment of their employees, all employees, through an electronic system developed by the government. Okay, but let's continue. And let's assume you are coming to the end or you're just beginning your OPT time, whether it's STEM or whether it's regular. And now you're starting to think about, okay, this is going to come to an end. What's next? Okay, and I want to again encourage you guys to really be thinking ahead. Obviously, you would be. That's because you're on this call with me. It's really a good sign. Always be anticipating what's next so that you can be prepared. All right, so what is next? Well, there's 4 possible next scenarios that we're going to discuss in our time together. The first scenario, and the most likely scenario, is finding another non-immigrant visa category. That is a temporary visa category. You're all on F1 or J1 visas. which are temporary for students and trainees, exchange visitors. You're now going to be looking for another non-immigrant visa, another temporary visa, this time not to allow you to go to school, but to allow you to work. So we're going to be talking about that in a minute. Another option for you, number 2, is going directly for a green card or subsequently getting a green card after you have a non-immigrant visa. There's a couple different ways to get a green card. We'll talk about all of them. The third option is whether you potentially would qualify for asylum in the United States, and I will briefly touch upon that. And finally, whether you could potentially qualify for what's called temporary protected status, or TPS. Okay, I'm going to deal with those last kind of miscellaneous ones right now to get them put aside, but it may well be, guys, that this is something available to you that you could consider. So going directly for a green card, generally speaking, is 2 ways. One, through employment, where you have an employer that is sponsoring you. We'll talk about that later, but also through a family relationship. So if you are married to or potentially getting married to a US citizen, that relationship, as long as it is legitimate and legal, is a basis on which you can pursue permanent residence status. So again, if you're in a relationship or you get into a relationship where you're getting married for love, not for a green card. I'm sure you guys have all seen those TV shows, which we don't need to talk about. If it's a legitimate relationship, that is an option for you to be able to stay permanently. We shall also talk about asylum. Hopefully none of you have experienced this, but there are people, of course, who have a, quote, well-founded fear of persecution if required to go back to their home country on account of their race, religion, national origin, political opinion, or membership in a particular social group. If that could potentially apply to you, you may be eligible for asylum, which is basically seeking protection of the US government to enable you to avoid having to return to your home country. If you face that situation, that's something that you can explore, and perhaps we can talk about that separately. And similarly, and especially under the new administration, has been an expansion of what's called temporary protected status. Temporary protected status, or TPS, which gives a temporary status to people in the United States from certain countries, which again are faced with all kinds of problems, and in which the person would have a fear of returning. Recently, Venezuela was added to that list, and other countries, their citizens are eligible for temporary protected status. Again, that's a separate issue to discuss another time individually, but I just mention it as an option. Okay, so the bulk of our time will be spent on those other non-immigrant visa options. So let's go through a scenario. You've graduated from Duquesne with a degree in, let's go with computer science today, okay? And you have a bachelor's degree in computer science from Duquesne, and you are working on your OPT for IBM, okay? Nice first job, right? You have OPT. You are eligible for STEM OPT because your degree is in computer science. And so you have 3 years of OPT because IBM is an E-Verify employer. Well, you're beginning your 3rd year, or maybe you don't have STEM, you're beginning your 1st year, and you're starting to think about, what do I do when this is over? Well, the first thing that should be coming to your mind, and will hopefully to your employer, is what's called an H-1B visa. H-1B visa. Now, the requirements for an H-1B visa are very straightforward, and all of you, I think, would satisfy them. Specifically, number 1, you have to have at least a bachelor's degree in a relevant academic discipline. Bachelor's degree in a relevant academic discipline. Number 2, the position that you're offered has to require at least a bachelor's degree in that or a similar discipline. And number 3, you must be paid a salary that is at or above the prevailing wage rate. That is, the government determines, based on a salary survey that is online, what is the, quote, going wage rate for a software engineer or computer systems analyst in Pittsburgh. The offer that you get from this H-1B petitioner must be at or above that amount. And the reason that is, guys, is the government wants to make sure that US workers are not being undercut by foreign workers. So foreign workers must be offered wages that are the same or more than the prevailing wage rate to US workers. Okay? So those are the three requirements. And turning to our hypothetical, you can imagine that this person's probably being offered a software engineering or a systems type position with IBM. And so those requirements would be satisfied. H-1B visas begin with the filing of a petition by the employer with the Immigration Service. Those petitions typically are processed in approximately 3 to 4 or more months. If the employer chooses to do so, it can expedite that process by paying the government an additional fee of $2,500. Okay? But normal processing of an H-1B petition is approximately 3 to 4 or more months. Once that petition is approved, the person is, generally speaking, eligible for H-1B status. Now, if you are in the country at the time of filing, that is, you are legally in F1 student status, this can be done on a change of status basis. That is, you're in F1 status, we're changing you from F1 to H-1B. If you're outside of the United States, you can still get your H-1B visa, but just like you got your F1 visa stamps in your passport, you would have to go to the US consulate in your home country. Okay, so hearing that, you're thinking hopefully that this doesn't seem too bad, and the requirements are not bad, and the procedure is pretty straightforward, but the very significant complicating factor is what's called the H-1B quota. All of the other temporary visas that we're going to discuss this afternoon, have no limitation in terms of the number. You can get as many of these types of visas as you want. With the H-1B visa, however, they are limited by quota. Specifically, there are 65,000 new H-1B visas available every year, plus an additional 20,000 for people who graduate with a master's degree or higher from a US academic institution. So a total of 85,000 new H-1B visas. These H-1B visas become available at the beginning of every government fiscal year, which for our system is October 1 of every year. Okay? Now, 85,000 may sound like a lot of visas, but believe me, it is not. Back in the day when we were in a technology boom and there was a recognition of there was a need for more H-1B workers, and there was more of a positive view toward employment-based immigration, which we'll touch on at the end, there was as many as 185,000 or up to 200,000 H-1B visas available. Well, now, as I said, the number has been reduced to 85,000. And what has resulted is a significant backlog, a queue for H-1B visas. Simply put, the demand for H-1B visas far exceeds the supply. So as a result of that, what has been set up over the past several years is a lottery where we literally have applicants submit an application, what's called a registration application for one of the coveted H-1B visas. Those registration applications need to be submitted on or about March 15th of every year, between March 15th and March 30th. And during the first week of April, or in this year, even before, the government announced the lucky winners of the H-1B quota registration process. We don't know yet the total number of applicants, but based on the percentage of cases that were accepted, which was less than 25%, it could well be that we had in excess of 250,000 applications or more submitted for the 85,000 slots. So the way this works, guys, is that you must approach your employer. The employer must file a registration application for you before the deadline, because if you wait until after the registration deadline is passed, you obviously will not have any chance of getting a visa for that particular fiscal year. So we submitted in our office several hundred H-1B registration applications for our clients by April 1st and learned shortly after which of those applications were accepted for processing. So in our IBM scenario, what IBM would be doing is submitting a registration application for the Duquesne graduate, hoping that that registration application is accepted. If it is accepted, IBM would proceed to prepare and file an H-1B visa petition, effectively addressing the three requirements that I mentioned. The person has a degree in a relevant field, the job requires a degree in that field, and the person is being paid at or above the prevailing wage rate. And because the person would be legally in the country at the time of filing, that application could be filed on a change of status basis, meaning effective October the 1st, which remember is the first day of the government's fiscal year, he or she would be in H-1B status, able to continue working for IBM. Okay, so that's the way the H-1B process works. Practically speaking, guys, because of the quota, it is essential that you have a discussion with your employer up front about this H-1B cap situation. Now, it may be that you have that discussion even before you start on your OPT. That's a little risky, of course, because you want to make sure you don't turn off an employer. Hopefully, you're going to do a really good job as soon as you start your OPT, and they're going to be willing and anxious to do this for you because they want to keep you on board. But it's really important, either before you start or after you start, that the employer is aware that you need this. Because if they don't file by that deadline, as I said, they're going to be waiting till the next fiscal year to be able to even try for an H-1B visa, which may be after when you have to leave the country. Okay? Okay, there may well be questions about that. We'll leave plenty of time at the end. All right, so what happens if the H-1B is not available? Let's say you have an employer that won't sponsor you, you try it, you're not selected in the registration. What other options would you have as a Duquesne student who's graduating, looking to be able to continue working? Well, a couple that I want to mention. Number one, if you are a Canadian or Mexican citizen and you have a degree, you may be eligible for what's called TN, Trade NAFTA status. So under the US-Canada-Mexico Agreement, which used to be called the North America Free Trade Agreement, NAFTA, Canadian or Mexican professionals can get TN status based on a job offer from a US employer. So in our case, with our IBM person, with that degree in computer science, it's likely this professional, if he or she is from Mexico or Canada, would qualify for TN status. TN status is valid for an initial period of 3 years and can be extended indefinitely. By the way, the H-1B visa is valid for an initial period of 3 years and can be extended for an additional 3 years, or a total of 6. So TN if you are Canadian or Mexican. There's another category called an E3 visa. If anybody on the call is from Australia, there's a special treaty the United States has with Australia, where Australian professionals can get E3 visas, very similar to H-1Bs, but only available to Australians, but not subject to any quota. There's also what's called an H-1B1 visa, which is for nationals of Chile and Singapore. If you're from one of those countries, again, it's just like an H-1B, but not subject to the H-1B quota. Now, I will also mention here, before I get off kind of the H-1B area, that if you have already been in H-1B status, let's assume, guys, that you graduate from Duquesne and you get a job with IBM and your case is selected and you have H-1B status effective the beginning of the fiscal year. Well, if you change jobs and go to work for a different employer, Google, you are not again subject to the quota. So you're only subject to the quota one time. You can transfer your H-1B visa from employer A to employer B to employer C without having to worry about being subject to the quota again. So that's one of the reasons. A practical bit of advice to you guys is this. If you have an employer that may be willing or is willing to sponsor you for an H-1B visa, and maybe it's not the dream job you're hoping for, take it. Take advantage of it as long as you can, as long as it's a job that you would consider. Because again, as long as you get through this H-1B registration and get your H-1B visa and are going to work at this company and you work there for a period of time, if a better job comes up, you can always transfer your H-1B visa and not be subject to this quota. I'll also mention that H-1B visas are not necessarily automatically for full-time jobs. They can be for part-time jobs as well. So we've done a lot of H-1B visas over the years where people are working, say, 3 days a week or something along those lines, okay? So be flexible, particularly with your first job. Okay, let's assume the H-1B doesn't work out. You're not Canadian, you're not Mexican, you're not Australian, you're not from Chile, you're not from Singapore. What options do you have? Okay, here's a couple more. There's something called an E2 visa. E is in Edward II visa, which is an investor visa, where if somebody is able to make a substantial investment into a US business, which results in the creation of jobs for US workers, the person can effectively follow that investment and secure what's called an E2 visa to be able to work for that company in the United States. Now, the employee can either be the investor himself or herself, or can simply be a national, a citizen of the same country of the company or person who makes that investment. So, for example, if there is a German company that has made a substantial investment into a US business, what comes to my mind is Bayer, which made a significant investment to create Bayer in the United States, and you are a German national, you are eligible for an E2 visa to work for Bayer in the United States. Or if you personally or your family would be able to make a substantial investment, which again is not only enough to support you and your job, but to create jobs for US workers, that may be an option for you. A key requirement here is that the United States has a treaty with that particular country for E2 visa purposes. So not all countries do, but many of them do, and that's worth considering as an option. Now, a similar option is another visa, which is called an L1 visa. By the way, you may be wondering, where are all these letters coming from? Well, it's not particularly brilliant of the Immigration Service, but our visas are articulated by letters of the alphabet. So you have F1 student visas, and we're talking about all these other visas, which are based on letters from the alphabet. So the next one is the L1 visa, L1 intra-company transfer. So this is where, for example, if prior to coming to Duquesne, you worked for a company overseas, and that company happens to have a US office or subsidiary, or perhaps will establish a US office or subsidiary. On an intra-company transfer basis from the foreign company to the US company, you can effectively transfer with an L1 intra-company transfer visa. You must have worked for that foreign company for at least 1 year prior to coming to the United States, and you either have to have been a manager or what's called a specialized knowledge employee. But if that is a scenario that may be applicable, that can be a good option. I've had students in this presentation over the years where that was exactly what their situation was, and they were able to pursue an L1 visa. The final one I'll mention is what's called an O1 visa, which is for people with extraordinary ability in their field. And this is truly a visa for the best and brightest. And the regulation talks about people qualifying if they are a winner of a Nobel Prize. Well, suffice it to say, I haven't had many Nobel Prize winners knocking on my door over the past many years. And I'm sure all of you are great, but I don't think any of you are Nobel Prize winners. But I'm happy to tell you that that's not the only requirement you can satisfy. There's a whole list of criteria for people who, for example, have master's degrees or above, who are doing cutting edge research, who have worked for very well-known companies, etc. Now, you are all students graduating, so you likely will not qualify, but it's something just to keep in mind in case no other option is available. And perhaps you are coming out with a PhD and you've done some research, maybe that's an option for you. So the only other option I will mention of all of them is the possibility of going back to school. Okay, Mary Beth covered this with you well yesterday, but we have certainly had students who have been in F1 status, have gone to OPT, maybe even STEM OPT, have not been able to get an H-1B visa, or none of these other options are available. They have returned to an academic program where they've maintained their status, they've gone to school, and sometimes been eligible again for curricular practical training, CPT. So that's something to talk more to Mary Beth about, but as a last resort, that's something that may be considered. So let's go over them. We talked about the H-1B, the TN, the E3 and the H-1B1. We talked about the E2, the L1, and the O1. All non-immigrant visas, all ones for you to consider when you get to that place. Now, let's assume, turning back to our hypothetical, that our student has been working for IBM in H-1B status. And the student says, boy, I'd like to be done with a temporary visa. I've made my home in the United States. I'd like to get a green card. So as I mentioned, one option is a family-based green card based on marriage to a US citizen or some other familial relationship. But the general way that we do it in our office is through employment, okay? Employment-based permanent residence processing. Now, I can tell you that as a general rule, you do need an employer to sponsor you, which is to file the application on your behalf based on your employment with that company. There are, though, a few exceptions where you can pursue an employment-based green card on your own. The first one is for people with extraordinary ability. That should sound familiar. I just mentioned it. Same thing with the O1 visa. So if you're somebody who's truly at the top of your field, you can self-petition as a person with extraordinary ability. Also, if you have at least a master's degree and you are doing work which is in our country's, quote, national interest, you can self-petition the government for an employment-based green card. Now, what do I mean by national interest? This would typically involve research or other type of work in a field that is particularly important to the US at that specific time. So right now, you can appreciate people who are doing COVID-related research, people who are doing national security-related research, people are doing robotics research, which maybe has defense applications, people who are working in a laboratory that is developing a treatment or potential cures for various diseases. That's the kind of stuff we're talking about. Or from a business perspective, possibility of somebody who is developing business, creating jobs for US workers. So those are the limited circumstances where you might be able to pursue a green card on your own, but the vast majority of people need an employer to sponsor them for a green card. And again, this is where a discussion with an employer early on in your H-1B time, for example, makes a lot of sense. You guys, the H-1B visas are good for 6 years. If you're working for an employer and you're at the end of your 3rd or 4th year, and that employer says, we like you, but we're not going to sponsor you for a green card, we don't do that, or we don't want to pay the fees, then you may want to think about finding a new employer that not only will employ you, but will pursue a green card on your behalf. Okay, you really need to think ahead and watch out for your own interests to make sure you're protecting yourself. Now, let's say an employer does agree to do it. What's involved? Well, normally speaking, what's involved is a 3-step process. The first step of that process is called labor certification. You may have heard of this because this is where a U.S. company, U.S. employer, has to conduct a recruitment campaign for your job. That is, the employer needs to actually test the U.S. labor market to make sure that by hiring you, the employer is not taking a job away from a qualified and interested U.S. worker. So this is where an employer recruits, advertises for your position in a variety of venues through at least a 3, 4, or even longer month period, makes a good faith effort, importantly, very good faith effort to ensure compliance, to make sure that to determine if there are qualified and interested U.S. workers. If the recruitment campaign reveals a U.S. worker applicant who's qualified and interested, the employer cannot proceed with labor certification. But if the recruitment campaign yields no qualified and interested U.S. workers, again, after a good faith recruitment campaign, the employer can proceed and file this labor certification application with the Department of Labor. That process typically takes 9 to 12 months. And once it is approved, the employer can proceed to step 2, which is the filing of what's called an immigrant visa petition, which is, instead of a non-immigrant visa, we're now talking about an immigrant or permanent visa petition, because what the green card process involves, guys, is getting you a permanent status. It's not a temporary status, it's a permanent status. So we're now talking about an immigrant visa petition, or the filing of a form I-140. Those petitions are typically filed under either the employment-based second category, which is positions which require at least a master's degree, or the employment-based third category, which is for positions which require at least a bachelor's degree. Either way, the petition is filed with the Immigration Service, processed in approximately 3 to 4 months. Once that petition is approved, and sometimes while it's pending, the applicant can proceed to the third and final step in the green card process, which is adjustment of status. This is where the non-immigrant, in our case for IBM, a person with an H-1B visa, adjusts, if you will, from a non-immigrant status to permanent residence. This process typically takes about 9 months as well. So from start to finish, the green card process typically takes about 2 years. But, and this is the big but, every year, just like H-1B visas, Congress allocates a certain number of immigrant visas. And that number, for certain countries, the demand for those visas exceeds the supply. And in particular, and probably not surprising to you, those countries are China and India. So if you are a Chinese or Indian national, you are often faced with a situation where an immigrant visa, a green card, is not immediately available to you because the demand for visas in that particular green card category exceeds the annual supply. So if that happens, you are in a situation where once step 2, immigrant visa petition, is approved, you cannot proceed to step 3 until what's called your priority date or your filing date becomes current, meaning before a visa, a green card, becomes available. As those of you who follow this stuff may be aware, that waiting game waiting time between step 2 and 3 for Indian nationals in particular can be, believe it or not, more than 10 years. Now, the good news is that during that wait, you can continue to extend your H-1B status, but rest assured it is very, very frustrating. So we spend a lot of time advising our clients who are in that waiting situation what options they may have to try to expedite that process. But big picture, guys, it's an employment-based process, 3 steps: labor certification, immigrant visa petition, and adjustment of status. Okay, it's 12:42. I'm leaving 15 minutes or more for questions because I see a lot of stuff on the chat. I have more stuff, Aaron, that I could talk about, but why don't I turn it over to you and you can maybe give me the questions, okay?
Yeah, of course. We'll start with a question that we received earlier before the presentation started. Our first question is, I'm currently in the first year of my PhD program, and I want to get ahead of thinking about my future plans during dissertation and after I graduate. I'll be on CPT, and I'm wondering if it's appropriate to shift to OPT during dissertation. More specifically, I'm curious to hear about how PhD students navigate this transition.
Mary Beth, I'll turn that one over to you.
Thank you, Larry. This is always a tricky question. OPT can be pre-completion OPT or post-completion OPT, and that usually only comes into play when we're looking at students on the graduate doctoral level. If you do pre-completion OPT, it does take the place of post-completion OPT. So my recommendation is to do CPT as long as you can, but you never want to do CPT full-time for 12 months, or that will also take over and eliminate the availability of post-completion OPT. So it's a little, tricky to navigate, but it's certainly something that we could work out on an individual basis. So if we have your name, the student that submitted that, I can reach out to you, or please just reach out to me and we can look into it a little bit more specifically.
I can forward you the email after. Another question, I'm also interested in EB1 or EB2 visas. What does the process look like for a PhD student, and are there any things that they can do right now to put themselves in a more favorable position in the future?
So the EB1 is, again, for people who are with extraordinary ability. That's EB1A. There's also an EB1B for people who are outstanding researchers or professors. EB2, people, as I mentioned, national interest waiver goes along with that. So the answer is that take a look at the regulatory criteria for an EB1 case. What that means is it's in the immigration regulations, there's a list of criteria that would render somebody qualified for that EB1 category. Things like publications, presentations, awards, citations to your work for well-known organizations. So anything that you can do during your PhD program to effectively beef up your resume and to satisfy as many of those criteria as possible will put you in a really good position for once you graduate to be able to qualify under one of those immigrant visa categories.
Thank you. And then one last question is, I've also heard about people from other countries getting sponsored to work, and they just apply for an employment authorization card. Is this a possible way to get a job after? And if so, what does sponsorship look like? Is
this all the same person, Aaron?
Yes.
Wow. I want to make sure that we don't run out of other people because we don't have much time. But basically what we're talking about here is a work permit is what Mary Beth was talking about yesterday with OPT. So you get a work permit, you get optional practical training, and then you're able to hopefully prove yourself to a US employer, which would be the basis of an H-1B visa or a green card application. So, what I say to students is get on board with a company, do a great job, convince them about your value to the organization, and hopefully convince them to then pursue an H-1B visa for you.
Thank you. And the next question from the chat room, can all employers hire and sponsor students on OPT visas?
Great question. The answer is yes, they all can. Do they all? Not necessarily. There are some employers who think about hiring foreign workers and without truly understanding what is and is not involved, simply say, we don't hire foreign workers. Now, is that legal? It's legal as long as it is justified by a business reason, which can, in certain cases, be the filing fees, the attorney's fees to get somebody on board. But this is a good practical point, guys. One of the things that you may be in a position to do is explain to employers why it is so easy for them to employ you. Remember, when you go to work for a U.S. employer, you're hopefully presenting to them on day one an employment authorization card that Duquesne and Mary Beth help you get. Okay? All they need to do is do the same thing for you as a U.S. worker, which is complete the I-9 form to prove that they're legally authorized to work in the United States. So as a practical point, this is another reason why to stay close to Mary Beth and her office. You got to apply for that OPT right away. You don't want to be in a situation where you're making things complicated for the employer. You need to be able to say to the employer, hey, I've already applied for my OPT. I either have it or I'll have it well before my proposed start date. The last thing you want to do is get a job offer and say, oh, I didn't do that, or I did it too late. It's going to take another 3 months and you lose out. So it's really important, guys, to be proactive and explain that that first step, the OPT employment, is simple for an employer. The H-1B is not so simple, but hopefully you prove to them why you're worth it.
Thank you. And our next question is, if I work for a family-owned business, an accountant for a restaurant, do I qualify for a work visa?
Well, if it's a legitimate job, okay, the fact that the company is family-owned in and of itself does not mean you can't qualify for an H-1B visa. They can still sponsor you as long as it is a legitimate job. But you can appreciate, and that's where this question is coming from, if it's a family-owned business and they're hiring their son or daughter, then that could be really viewed very carefully with scrutiny by the Immigration Service. So as long as it is a legitimate job, as long as you're being paid the prevailing wage rate, as long as you're being treated like other employees, that is definitely something that can be considered, but needs to be prepared very carefully.
Okay, thank you. And then for H-1B, does the position have to be salary or can it be a contract?
It has to be a salary. You have to be paid at a salary that is at or above the prevailing wage rate. So if, for example, you get a base salary plus commission or percentage or based on performance, that is not sufficient. You must be guaranteed a salary that meets or exceeds the prevailing wage rate.
Okay, thank you. The next question is there any specific provision for applying for U.S. citizenship for a PhD student? I believe there might be a typo in that.
Okay, so I can't see the chat anyway, Aaron, so I'm trusting you, buddy. So the answer is there is no direct path for anybody directly to citizenship. In order to become a U.S. citizen, you must first be a permanent resident. And general rule is you have to have been a permanent resident for at least 5 years. The exception is if you obtain permanent residence based on marriage to a U.S. citizen, that naturalization period is 3 years. But there is no fast track from a PhD to citizenship. There may be a fast track from a PhD to a green card if you could qualify under that EB1 self-petition category, but certainly not to citizenship.
Hi, thank you. Next question. My fiance is a U.S. citizen. How can I stay in the U.S. legally after graduation until we get married?
Okay, so that is a very important timing issue. Simply being engaged to a U.S. citizen is not sufficient to allow somebody to stay in the United States after they graduate. Some filing has to have been submitted. So if the person is engaged, if it is a legitimate relationship, one option to consider would be to get married perhaps earlier than initially anticipated, again, assuming it's a legitimate relationship, and on the basis of that marriage, apply for permanent residence for the student. The filing of the permanent residence application keeps the person in the country legally. It's a filing keeping the person in status. But again, simply being engaged is not enough. And that's a student, that's a situation that I face a lot. And maybe that's a student, if they're interested, can reach out to me afterwards and we can talk.
Okay. Next question is about H-1B. Is there a type of H-1B visa without doing the lottery, such as working for a nonprofit organization or for colleges and universities?
Great question, and I should have mentioned that. Thank you for raising it, whoever did. So there are a limited number of visas that are not subject to the quota, which are identified by this question. Number one, if you get a job offer from a college or university, you are not subject to the quota. So when I do my H-1B cases for Duquesne, happily, we're never subject to the quota. Number two, are nonprofits that are affiliated with an academic institution. So it's not enough, guys, that you get a job offer from a nonprofit. That nonprofit has to be affiliated with an academic institution. So when you're thinking about your job search, that definitely is something to consider. Can I find a job with a company or an employer that is not subject? Remember, though, importantly, let's assume you get a job teaching at Duquesne, and then a year later, you decide that you want to get into industry. You want to go to work for a company. Guess what? You're subject to the quota. So just having a non-quota employer does not mean you subsequently won't be subject. You will be if you move to a non-exempt employer. Okay.
Thank you. That makes sense. Mary Beth, this might be for you. Do we get an additional 2 years of OPT for STEM majors?
Yes, it's 2 years, 24 months. So it'd be a total of 3 years together for STEM.
If you have a job offer from an E-Verify employer.
Correct. And I will say, in order to be eligible to apply for STEM after the completion of the first year of OPT, you have to have a job offer in order to apply, and you have to apply before the end date of the first year of OPT.
Okay. Thanks. And our next question, and just a reminder, we do have about 6 minutes left before 1 o'clock. So if we're unable to get to your questions today, I've put Mary Beth's information in the chat room. Please feel free to email her directly to have any of these questions answered, but we'll try to get through a few more before we wrap up today. So if a student begins OPT in September 21, does the employer have to submit the registration application by April 1st, 2022, and then apply for OPT October 2022?
Well, if they started, if my understanding is the OPT began September 1, 2021. If that's correct, yes, the registration application would have to be filed on or about March 15th, 2022 for an H-1B petition to become effective October 1, 2022. So that question actually said for the STEM to become effective October 1, 2022. No, the H-1B becomes effective October 1, 2022.
Okay. And then is the H-1B available for a maximum of 6 years?
6 years. Go ahead, Mary Beth.
Yeah, the one thing I would just add into that previous question is there may and often is a short period of time called a gap between which an OPT ends and an H-1B starts. And that is something SEVIS and USCIS works with to offer a gap coverage so that there's no lag time in between. So I'll just point that out just for the students who might be wondering.
Yep.
All right, thank you. Another question. I graduated with a biology major and now I'm in law school because I'm interested in health law. Would I qualify for the STEM extension?
Mary Beth?
I think it would depend on whether the student did OPT for the first year of the biology. but it's tricky. I've actually had a similar student reach out to me, and we were not successful in pursuing because the student was attending for their PhD at a different university, and they were no longer here at Duquesne. So their I-20 was no longer under my control. So we ended up not being able to pursue it. If it's all been done here at Duquesne, there might be. So that student could reach out to me.
You know, and I just add, I think it's unlikely that that's STEM OPT because the person has done a subsequent degree program, and I think that that STEM OPT is gone.
I agree. Yeah.
All right. Maybe another couple questions before we wrap up. If you apply for a green card in the final year of H-1B, can you still work if the H-1B expires and your green card application status is still pending?
So the general rule, guys, is that an H-1B visa is good for 6 years. It can, though, be extended beyond the 6 years if you have made a certain amount of progress toward getting a green card before the 6 years expires. So I don't want to get into the details here, but if you are from India or China and an immigrant visa is not immediately available, that you have that delay that I was referencing, getting far enough along in the green card process may be a way to extend beyond that 6 years. And that's something to discuss with your employer, but also a real reason to not put yourself in that position, if possible, and get started on the green card as quickly as you can.
Okay. Does the employer need to pay to hire me on an OPT to do the STEM extension and apply for an H-1B, or is it just the attorney fees and filing paperwork?
So for the OPT, there's no payment, but for an H-1B, yes, the law requires the employer to pay any and all costs associated with the H-1B process, which is the attorney's fees and the government filing fees. So, you know, I've had situations where students have said, wait a second, they're willing to do this, but they're not willing to pay for it. What do I do? And my answer to that is, unfortunately, you can't do anything because you're not allowed to pay this. The employer must do so. And of course, the other question I get is, well, how much does it cost? So my answer is, it depends on the attorney and it depends on the situation, but typically the H-1B visa petition for attorney's fees are anywhere from $2,000 to maybe $5,000. And the government filing fees are typically around $2,000.
All right, and I think our last question, we had two students ask a similar one. What is the best date to start OPT for an August 7th, 2021 graduation? Or graduating December this year? When is the best time to start applying for OPT?
Mary Beth?
I can take this one. You are only permitted to apply up to 90 days prior to the completion of your program. And we'll use the end date on the I-20 for that specific date. So take the end date on your I-20 and go back 90 days. Yesterday, if you were participating, I mentioned, start working with my office with me about 100 days before that end date so that we have a little bit of buffer. So when 90 days comes, you can drop it in the mail. It does take 90 days to process. It's a rare exception. It takes less than that. So if you are eager to start work right upon graduation, the sooner the better. And you also have 60 days after graduating that you're still eligible to apply, but only 60 days. We had someone apply 61 days and it was denied.
Exactly.
All right, well, I think that wraps up our time here today. Thank you, everybody, for all the questions that you had. Special thank you to Larry for joining us. Thank you, Mary Beth. I think this has been very helpful.
Aaron, let me just say one more thing. One of the things, everybody, that I've offered to Duquesne students over the years is a reduced consultation fee, where if you speak to Mary Beth and you have a particular situation, then I'm happy to meet with you for a reduced consultation fee of, for a half an hour or whatever it takes to talk about your particular case. So I do charge a fee, but it is a lot lower than my standard fee, just as a favor to my friends at Duquesne. So Mary Beth has my contact information. If you would like to speak with me, I'm happy to do so. Okay, and thanks for the opportunity, Mary Beth and Aaron. This was enjoyable. I hope it was helpful.
Very much so.
Absolutely.
Great. Okay. See you again,
Thank
everybody.
you.
Have a good day. Thank you.